During today's program, we're going to be discussing a few different issues, and one of them is the consequence of departing Canada. It's the same, by the way, as departing the planet. So when we die, from a tax point of view, you know there's capital gains taxes to pay. Well, the same is true when you leave Canada. It's treated as though you've died to Canada. So therefore, it's very, very important to keep that in mind. The other thing that you want to think about is assets that you have here in Canada. Say there's various different corporations. How are you going to be able to deal with departure taxes post your departure? And when do you depart Canada? So this is a very big subject, and I don't want to, sort of skim through like a speedboat and leave some very important things behind. So I think before we get started, maybe I'd call on David Lesperance, maybe to comment on the concept of tiebreaker rules that exist between various different treaty countries, and when a person departs Canada from a tax point of view. So maybe David, if you don't mind kicking things off, and let's dig into some really interesting subjects here.
Sure. So there's kind of three parts to any decision relating to the release. One is, why are people motivated to go? Sometimes they're motivated being pushed out by things that are happening in Canada. Sometimes they're being attracted by something happening in another jurisdiction. We'll talk about the how, and Todd will go through that. We know that if you leave permanently and become a non-resident, that's a deemed disposition. So how can we plan for that? And where do you go? So do you go to a jurisdiction that has a tax treaty with Canada? What are the pros and cons of that? What if you kind of want to put your foot in the water, but you're not sure you want to leave, and you're going somewhere, and where can a tiebreaker rule, come into effect there? So I haven't triggered the deemed disposition yet. You want to make sure, if you're leaving Canada, both from a tax and a lifestyle point of view, that you don't kind of jump out of the pot into somebody else's fire. So you really want to kind of think about that. And going to motives, I've been dealing with, I personally become non-resident in Canada 3 times. The last time was just before Mr. Trudeau the Jr., as I call him, ascended the throne for the first time. And it really, for me, it was all lifestyle driven. I was coming, the last time was, I was living in downtown Toronto. I had young children. We lived in a place that was great for double income, no kids. Not so great for little kids. Not a lot of places to go, parks, etc. And so we really moved out of Canada, not driven by whatever concerns we had about an incoming government, but more of a lifestyle choice. And that's oftentimes the case. Some clients are worried about things such as wealth tax proposals, or loss or restrictions on principal residence exemptions, increasing in income tax rates. These are all what I call wildfire concerns that clients have, and they take into account maybe they don't like the political direction of the country. Maybe they don't. They're motivated by saying, I live in a high stress jurisdiction and I'm retiring. The house is empty. I no longer need this big house. I want to move somewhere else. That's really a lifestyle choice. So we do get those reasons. So if you're worried about a wildfire concern, the natural thing is, okay, well, I'm going to engage in fire prevention. That may be tax planning, that may be moving to a different location, and those are all domestic solutions. But you may also want to look at fire insurance, which would be an alternative place to live. Canada doesn't, unlike the US, have citizenship-based taxation. So there was a proposal a few years ago to consider that, but it's not really, on the table right now. Not that it couldn't be in the finance minister's mind for future budgets, but who knows? And so you get that fire insurance of where am I going to live? And you've got the fire insurance if you feel it comes to your fear of the wildfire overcomes that life inertia that you have of living in Canada, you want to make sure you have a fire escape plan. Now, just because you have fire insurance and a fire escape plan doesn't mean you have to trigger it. It just means that if you reach that point for yourself personally, you're going to do that. You've got a good place to go, and you're doing, as Todd said, failure to plan is planning to fail. You planned appropriately.
Excellent. That's great. So, David, you've given us some very interesting things to think about as far as why some people are actually asking, what is the implications? But I'll tell you, something else tends to happen. Maybe I'll have Andy comment on this one. I would suggest there are circumstances where individuals cease to be a resident of Canada without even knowing, which can trigger a taxable event. Andy, can you explain that for the audience, please? How that happens?
Well, we've met a lot of clients where after they left Canada, they come back to us and didn't realize that there's a departure tax in Canada. So one of the main types of deemed disposition, the first one is death, where you deem to dispose of all your assets. And the second one is when you depart from Canada, where you deem to dispose of all your assets and acquire them at a fair market value. Now, there are several items that a Canadian tax resident should consider before leaving Canada, including A, the amount of departure tax, and B, whether, let's say, they could utilize the lifetime capital gain exemption, which is available to all individuals in Canada. And there are steps that can be taken prior leaving Canada to purify the company, such that they have access to that $900,000, almost $1 million now, of lifetime capital gains exemption by making sure that the companies remain as qualified small business corporations. And C, once the shareholder leaves Canada, any future dividends the shareholder receives from the Canadian company will be subject to withholding tax, sometimes up to 25%. So it's worthwhile to set up a structure and consult with tax experts to perhaps set up a structure and analyze the tax treaty, depends on which jurisdictions you go to, and as to how to reduce that withholding tax. Otherwise, all your assets will be stuck in Canada, and you cannot get that until you pay that 25% withholding tax.
Excellent.
Yep.
Oh, sorry.
No
Please.
worries. I was just going to cover the last type of deemed disposition, which is for trust. So as you know, every 21 years, trusts are deemed to dispose of all the assets, and we acquire them again at fair market value. So if one of your family trusts in the audience is reaching that 21-year mark, you should talk to a tax expert.
Excellent. All great points, Andy. So I'm going to take a step back for a moment, and I'm going to say I lost count of how many people have come to me over the years after unknowingly and unwittingly maybe departing Canada. Oh, I've abided by the 181 days. Well, guess what? That's an immigration number. That does not necessarily apply to from a tax point of view. So in effect, I'll talk a little bit, about a center of vital interest, and really that's really what the key is determine when an individual has shifted his center of vital interest from Canada to another country. So there's different rules that apply to whether it's a country that you're emigrating to from Canada and immigrating to, who has a tax treaty with Canada. In that event, there are generally rules that are called tiebreaker rules. And these rules determine where a person has crossed the line, ceased to be a resident of Canada, and has begun a residency in another country. And as David mentioned, Canada has a residency-based tax system, unlike the US, that has both residency and citizen-based tax system. Well, the reality of that is that it might be that prior to the 181 days, you may have ceased to be a resident of Canada. And that may have triggered a serious taxable event. So understanding perils are very, very important. And then preventing these perils, I think, are equally as important, but you cannot do the latter without doing the first. You have to first understand what the issues are. So there's a couple of comments there, and I think that I sort of drew a parallel earlier to the fact that, when we depart from Canada, whether we decide to move south to a warmer climate, or whether we decide to leave the planet, or otherwise not decide but do it anyway, it's really the same tax consequence. So maybe Jordan would explain a deemed disposition as far as helping the audience to really understand a deemed disposition and also deemed proceeds. Would you explain that, Jordan?
Sure. So absolutely. So at death or upon departure from Canada, rather than the assets being disposed of in an actual sale or whatnot, they would be deemed to have been sold deemed to have been sold or disposed of for tax purposes. So it's the exact same treatment if you were to pass away or if you were to depart Canada, as it would be if you were to sell those assets at fair market value, essentially. So you would at that point have to pay, your estate would have to pay the capital gains taxes if you were to pass away on the growth of the assets that we're talking about. As per the next point that you talked about in terms of a deemed value disposition at that point, so that would apply to property, for example, that may be that may be gifted from let's say the parents to adult children, for example. And so although they may gift that property at a value of $1, for example, they would be really taxed on the capital gain between the adjusted cost base or the original value of the property between that as compared to the fair market value at the time of the disposition itself.
Mm-hmm. Yeah, thanks, Jordan. So the interesting thing now that these terms are all coming up, I mean, it's very important to understand that the way that CRA will look at fair market value will be the highest price that one would pay in an unrestricted market immediately prior to departure of Canada, immediately prior to death, or immediate or upon the sale to a non-arm's length family member that Jordan's mentioning, who might, I mean, we've had people say, oh, I'll just give my company to the kids. Well, that's nice. The whole problem with these kinds of transactions is they all contain not proceeds of disposition, but deemed proceeds of disposition. The deemed proceeds of disposition will not pay the tax. The tax has to be funded. It has to be paid. It has to be planned for. And there's certain things that one can do. So one of the concessions that I would ask everyone to think about is the possibility of how you can mitigate the tax to begin with. And this can be done in a number of ways. As an example, a rollover, which pretty much all of the accountants would be familiar with, and the lawyers that are in attendance, most of them, depending whether or not you do corporate law or not. If you're a business owner, well, you've heard of rollovers, undoubtedly. Well, one of the reasons I'm talking about rollovers is because a simple transaction that involves taking the shares or a capital asset, and essentially transferring the ownership into a shell company and taking back shares that have a stated value that is equal to today's fair market value is attainable. And it's a very simple procedure. And it's a very important step to look at. One of the things that it will achieve when you do this kind of rollover is it can be combined with asset protection. In other words, once you take a capital asset or shares of a company and transfer it to a corporation, take back these fixed value shares, I'm talking about preferred shares, it allows you to be able to do something incredible. It allows you to do something that we cannot do in the United States. It allows you to be able to mitigate or hold the level of tax that would be paid on departure or on death at today's value. Then what it does is we're then able to essentially give away all of the future growth of that asset. You can do that with real estate. You can do it with various different types of capital property that would make sense, that appreciate. And one of the biggest benefits comes from a company that's likely to grow in value as well. And by giving these future shares away, I'm not talking about charity, I'm talking about setting up a family trust that would allow you to accrue all that future growth for the next generation without facing this mammoth tax bite. Okay, so this is something that can be done in preparation for one day moving south. One day, a lifestyle change, leaving Canada. And if you don't do anything, you'll be caught feeling pretty much unaware and maybe even victimized. So David, I'll go back to you again. So we've been talking a little bit about, the why people leave Canada. I'd like to talk about the wheres, and I'd like to talk about, what some of the implications are and how we can best mitigate some of the profound effects. And maybe start off with lifestyle and give us an example of a jurisdiction that an individual at a certain stage of life might find appealing, and an individual different stage of life would maybe choose a completely different location. And then from there, we're going to drill down on the tax issues.
So I like to say that tax planning and the numbers, that's a boardroom table conversation, but this type of planning needs to be sold at the breakfast table. So all the family members have to decide kind of where they're going to go. Occasionally I'll get somebody to say, well, I want to go somewhere where there's no taxes, no lawyers, et cetera. I say, well, we can move you to Pitcairn Island in the South Pacific, but only 68 people have decided, no. I want schools, I want medical facilities, I want restaurants, I want office buildings, et cetera. So it's really understanding for yourself and all the people that are going to be involved. And so somebody who's at the stage where they have school-age children is going to look at jurisdictions completely differently than an empty nester or a single person. Are they going to be active in a business? So one of the places a lot of Canadians, of course, think about is moving to the United States. And they think, well, I'll move to a low-tax state like Florida or Texas. I'll stay out of New York, I'll stay out of California. That's fine. That may deal with the state level of taxation, but you have to be aware of US has its own taxes that Canada doesn't have, not just income and capital gains, but gift and estate taxes. And again, proper planning lets you avoid stepping on those landmines. We have clients that say, okay, I want to move to, an island in the Caribbean, Turks and Caicos, very nice place. Lots of Canadians go there. Beautiful beaches, beautiful diving, direct flights from Canada, but not really great if your real concerns are, you have significant health concerns and you want to get, dialysis or things like that. Other places like Cayman, they have medical tourism, they have great tertiary hospitals, et cetera. So taking into account, what all the family members need and finding a jurisdiction. Another thing is Canada, of course, is a country of immigrants. So a lot of estimates of anywhere from 30 to 40% of Canadians will have claim to a European citizenship through an ancestor. And they may say, well, I don't want to go live in the old country. Well, you have to remember, if you're a citizen of any one of those EU member countries, that gives you 27 different choices, places that you have the right to live, work, and study in. Oh, well, Europe has high tax rates. Hold on. 6 of those jurisdictions have specific programs that minimize or even eliminate non-local tax. Oh, okay. Well, now this is interesting. Where are those places? Well, okay, there is the UK has its remittance basis, but that same tax basis is also present in Ireland, Malta, Cyprus, Portugal, very popular place. It has something called the non-habitual tax resident regime. Other jurisdictions, Italy, Greece, Switzerland, they have a lump sum. Oh, I like Italy. I'm going to move to Italy. Well, Italy, if you're going to some jurisdictions, has a lower tax rate. Across all of Italy, you can have a lump sum of 100,000 euros. Well, if you're paying $1 million tax in Canada, 100,000 sounds like a good deal, especially because you don't have any compliance costs. You don't have to worry about, is this a taxable dinner or a personal dinner? What's the mileage on my car? What are, you write a $100,000 check, whether you make, $1 million or 100 million. So those jurisdictions, oh, well, this becomes attractive. It's also, if you've got that entitlement to lineage citizenship, the rules vary from country to country, you can get it. And Todd, it's one of the things I swear my siblings and I didn't go out night clubbing looking for Europeans to dance with, but my sister married a Latvian, my brother married an Italian, I married a Scotswoman and a Pole, and my younger sister married an Irishman. Now, I'm the only one of the four of us to actually pick up and move to Europe, but I can tell you all of my nieces and nephews have done everything from study, gap years, work. I got a nephew that graduated from Trinity in Dublin that's working in Dublin now. I've had a niece that's been living in Brussels on her Italian citizenship for 10 years. It's a gift that you can give to your children and future generations. Another one is a large number of Jewish Canadians are thinking about Aliyah in Israel. And Israel has, if you're going to move to Israel, it has some very 10-year tax holiday. So Israel is attractive to people, both from retirees to entrepreneurs. So all these jurisdictions, it's kind of a meld of what's going to work from a lifestyle point of view, and then let's make it once you've made that decision, let's make it as tax efficient as possible. But don't rule out jurisdictions that you think, oh, well, that's high tax Europe, I'm not going to go there, or oh, I'm going to go to, a zero tax jurisdiction, small island. Well, that may not be appropriate for you. It may not be something, that you can sell at the breakfast table.
Yeah, no, I think that's a really good point. So tax on foreign income, some countries have, some countries don't. Withholding taxes from say dividends paid out of Canada or other countries. Well, so as an example, when there's Canada does not have a tax treaty with St. Lucia, as an example, that it does with Barbados. Interesting is there's no tax on foreign income in St. Lucia, but there is in Barbados. Sometimes what it's a matter of saying is what makes sense from a tax efficient point of view. And if we're looking to pick a third jurisdiction, say as an example, we're paying dividends from a Canadian company outside of Canada. Question one is, what does the tax treaty provide as far as a dividend rate that's paid to a corporation? If you have a U.S. corporation, say it's a C corp, and you're paying dividends into Canada, rather than paying a dividend tax of 15%, it's only 5%. Well, the same may be true depending on other jurisdictions. So since it's become, again, so terribly popular that so many people are desiring to leave on account of tax, I think these are very, very important considerations, but not only from a tax point of view, but also, as David's pointing out, just from a lifestyle point of view, what really makes sense to that individual. I noticed there's a question here about Dubai. What can you tell us about individuals considering immigrating to Dubai, David?
Well, this is actually, Andy and I can answer this question because we've got a Canadian resident who is moving to Dubai. So, and who has ongoing Canadian source income. Yeah. And so, as I'll leave Andy to explain the tax treaty and the withholding rate, but the UAE, it's a jurisdiction I first went to in 1990. My partner lived there for 25 years, so we know, the UAE quite well, and it's very attractive for a lot of people these days, from starting their careers to, retirees. And it has a lot of the elements of that you can sell at the breakfast table, from schools to medical facilities, etc. The deal on the UAE is, if you're either starting a business or you're just buying real estate, you can get a residence permit. So the immigration is fairly straightforward. And I'll leave you to Andy to talk about like the tax consequences and planning that we did for that client.
Thank you, David. So yes, we recently have a client who departed Canada and moved to actually another jurisdiction, and then to the UAE, looking to move to the UAE. And one of the issues that we're analyzing is, how do we get the assets within a Canadian company into our client in the most tax efficient way? So we look at a treaty, and generally there's a 15% withholding tax for all dividends paid from a Canadian company to say a Dubai individual or company. But under the treaty benefit, it can be reduced to 5% if the beneficial owner of the company controls directly or indirectly 10% of voting power in the, let's say, the Canadian company. And one of the more interesting issue that came up is that how to determine if a company in UAE is actually controlled by deemed to be controlled in UAE under the treaty. And not only you have to be living, the person have to be living in the UAE, but it also has to be a UAE individual, UAE national, unless you use another entity like a UAE control corporation or a trust. And for investment companies, the withholding tax rate is only reduced to 10% as opposed to 5%.
Excellent, excellent. I'll go a little further, and let's just say that this is not a promotion to leave Canada either, right? I'll maybe reverse this a little bit and say recently we had a client from the UAE who had a significant real estate portfolio. We had to determine whether or not it met the portfolio met the Canadian sniff test as an active business or not. Well, it had more than 6 employees and it had a portfolio of multi-residential real estate. And essentially, we were looking to bring $40 million into Canada on a tax-free basis through a Canadian tax concept called exempt surplus, right? So the fact is there's many things that can be done. And I'll say that oftentimes we will use secondary or tertiary jurisdictions in a fashion that would create a link. So when we talk about money leaving Canada, where is it going to go? There's certain reasons that people consider doing things. There's captive insurance companies that people end up setting up so that they can create a very strong tax benefit for self-insured risks outside of Canada, utilizing that concept and others. There's concept of using trusts in order to make sure the right kind of trust is used when you're, like if you're leaving Canada and you're using a NERT, well, there's a rule in Section 94 of the Income Tax Act that deals with an individual settler leaving Canada within 60 months. So it might make sense to use a foundation rather than a trust in some of these asset protection strategies. So what we're saying here is there's a lot to be careful of. There's a lot of awareness. Fundamentally, we started our conversation talking about being aware of the implications of tax at death or at death to Canada, meaning departing Canada. And what we've done now is we've talked about some of the mechanics that we have to be thinking of. So what I'd like to do is maybe come back to Canada again, and we'll just talk about some of the planning opportunities that we can do that have the eventual benefit on either of these two possibilities. I mean, some people say, well, it doesn't apply to me. Well, fine. It does actually. It applies to everybody. Unfortunately, everybody dies. Everybody gets to the age where they don't want to, they're not able to maintain assets and so on. They rely on the next generation. So when you consider what Jordan had described previously about, deemed value of an asset being transferred at fair market value, it's one of the big things. But let's change gears for a minute. We'll talk about family businesses. Maybe Jordan, why don't you talk about one of the issues there that have prevented individuals from doing certain planning and what kinds of benefits there are. I'm thinking of the capability for family businesses to utilize certain purification strategies, say butterflies in Section 55. The siblings deemed to be related.
Right. Well, I mean, when we're talking about eligibility for the capital gains exemption, I mean, it's a very important measure to be able to have the assets of a small business corporation or a company that has qualified small business corporation shares. It would be very important to have the assets to be looked at as purified, or in other words, the assets, at least 90% of the assets at the time of a possible sale or disposition would have to be actively used by the corporation in order to qualify for the capital gains exemption that we had discussed previously, that Andy had mentioned earlier. And so as Todd had mentioned, butterfly strategies can oftentimes be quite useful in terms of a method to be able to separate a company's active assets from non-active assets, which would include investments, perhaps life insurance with cash surrender value, as well as really just cash that's not being used by the company itself.
So this whole idea, I think there's been certain impairments that have existed for decades, one of which is this sort of planning, say single wing butterflies, being able to take cash as non-active assets. There's another example I can think of, and really it might mean that as an example, we've commingled foreign and domestic assets under a single holding company. Oftentimes we set up a new holding company and then we shift the foreign assets out or shift the domestic assets out. Another thing we do is we take a corporation and we shift out the assets, in other words, the client base and the goodwill the company has into another holding company. All of these things are amazing tools that need to be considered when you're thinking about leaving Canada. Andy already mentioned the capital gains exemption. Jordan's now talking about the fact that there's been a real severe challenge for family businesses. And one of the things that doesn't necessarily make a lot of sense, but it's just the law, and that is that, well, I suppose the legislature had a reason in its wisdom for coming up with the concept that siblings are deemed to be unrelated for tax purposes when it relates to Section 55 of the Income Tax Act. So one of the problems there is that this is a transaction that is only available to related parties. And since siblings are deemed to be unrelated, that means you haven't been able to do it. Another problem that I'll think of, and that is in family businesses, there's been a terrible issue there where individuals have been very much prejudiced by the fact that they haven't been able to claim the capital gains exemption, where the business has been transferred to the second generation. Bill C-208 has resolved both of those issues. It has provided for an opportunity where an individual who's rightfully retired to be able to essentially sell the shares to, say, an adult child's holding company and claim a capital gains exemption. This can be done through various funding mechanisms, which can provide for the purchase of shares with a promissory note that can be later be satisfied through dividends. A lot of people are coming to us asking for succession planning. They're asking for estate planning. They're asking for all of these things, but I keep coming back to this point that it's critically important to do the right thing in advance. Set it up properly from the beginning. Oh, when is the best time to do this kind of planning? So estate freeze is an example. Well, to me, if I had a client that came in my office today and said, look, we have incredible potential, well, I'd be saying, set up a trust, and hold the shares of the company. You've already achieved the effect of estate freeze at a fraction of the cost. It's already done early. Now, if the company isn't likely to grow in value and it's not likely to have tremendous success, my advice might be different. But if you're planning on success, it certainly makes sense. But most of the time, what we're seeing is individuals who have received advice that they're too young to do an estate freeze, that the company's not big enough, that their children are too old, or they're too young. And of course, none of these things are valid because all we're really talking about doing is structuring your affairs so that you have a deferral on capital gains tax by doing the rollover transaction into a corporation and taking back shares that have a stated value that will not be inflated. So I think that at the end of the day, one has to consider, when considering this kind of activity, what are the costs? Well, the costs we've already talked about if tax is high, but what about other costs? Well, there may be land transfer taxes that have to be paid when real property is transferred into a corporation. So I think that the issues are many that we have to be concerned about. One of the things that we would like to ensure that we have time to cover today is trusts and how trusts really work. So maybe I'll have Andy explain the concept of trusts for the audience, and then we'll talk about the different kinds of trusts and how trusts can be organized.
Sure, Todd. A trust is an old concept, and there are three main parties to a trust: the settlor, who basically provide the asset to set up the trust, which will be formed part of the trust property, and the trustee who manages the trust and hold legal title, but not the beneficial title of the assets within the trust. And the beneficiary of the trust who have the beneficial title of the trust properties and are eligible to receive some of those properties under the direction of the trustees. Obviously, I mentioned that 21-year deemed disposition rules for trust, and the two main types of trust that we usually do for clients. One is domestic trust, depends on the province, like Ontario, it could be BC, it could be Alberta, or the other type is international trust, where we could set up a jurisdiction where we think have superior asset protection laws, somewhere like Barbados, and use a corporate trustee who manages the trust properties on behalf of the beneficiaries.
Yeah, so I think the latter that you're talking about, Andy, is something that creates a lot of concern for individuals, and most likely because of not thoroughly understanding how a foreign trust used in Canada is really used, and how it's put together in a way that makes it really all about asset protection. And the fact that there may be certain tax benefits, well, I'm going to call them tax consequences. Whatever we do has tax consequences. Some might have a greater consequence or a lesser consequence. But at the end of the day, if we're considering an asset protection jurisdiction that is better than Canada, well, certainly it does make sense to ensure that things are done properly. So one of the issues that we always talk about is ensuring that the trust is not a sham trust, that the trust is not one that is self-dealing, that a trust is actually controlled by a trustee and not by the beneficiaries. There's a lot of misconceptions about trusts, and there's some case law that dealt with some trusts that were constructed very badly and resulted in fairly serious tax consequences. But it isn't necessarily so that because an individual sets up a trust outside of Canada, it's done to gain the tax advantages that are offered in that country. As a matter of fact, it's quite frequent when we do international planning that a trust that's set up outside of Canada is there only as an instrument to hold assets in Canada, such as shares of corporations and so on. And to David's point, basically one of the things to consider is what would happen if other perils came along. So say, as an example, that an individual became insolvent. Well, there's strategies that can be put in place that would deal with that. So in other words, an individual would have preferred shares or stated value shares because he did this rollover into a corporation, issued new shares to a trust. Well, there's certain provisions that we often put in trust in the shares that are held by the trust, so that the shares that are held by the trust acquire super voting control, which means that if a trustee in bankruptcy or a receiver in bankruptcy was to get a hold of those preferred shares, well, they wouldn't have the voting control, which means that a trustee couldn't interfere with the family's plans in the event that that happened. What about if an individual passed away and CRA said, well, wait a minute, you had extra control on account of some of the extra votes that you had? Well, one of the things that we do is, we don't think it'll happen, but if it did, generally we'd give advice to say that those shares do not necessarily have the voting control, because immediately prior to death, they're deemed to have been reduced to a fraction of the value. When it comes to, sorry, not value, I apologize, numbers of votes, not value. The value is the value. Very important distinction. So all of these things requires very specialized insight and planning. All too often, estate freezes and trusts are set up in a haphazard way. Andy has mentioned the reality that often when trusts get set up, years pass by, people are not even aware of the impact. Doing nothing triggers tax. I've also lost count of the number of trusts I've looked at and seen that the 21-year period's gone, and have to look at a person eye to eye and say you just triggered millions of dollars of tax for no reason. This shouldn't have happened. Well, these are all very critical areas that we want people to be aware of. I'm going to talk briefly about the importance of having shareholder agreements in family businesses. Most family businesses in Canada do not have shareholder agreements. That is a bad situation in every conceivable way. One of the issues and the most obvious things that probably come to your mind is if you had one family member who ended up passing away, well, suddenly the ownership of the shares would then typically go to a spouse. Well, without a shareholder agreement, you don't have a provision that would require that individual to be able to sell the shares back to other shareholders or redeem the shares for cancellation, which would normally be better for that person. It also, there's no prohibition on that individual selling the shares to a stranger. All of a sudden, you've got a stranger holding shares in a company, which is far from ideal. Another thing that can happen is disability can be a problem. Also, pledging shares as collateral to a bank might be problematic. When it comes to wills and will planning, if there's a complicated tax structure, all too often we see people with $100 million of assets, and either they have no will, and that's true. I've lost count of those as well. Or the will is done 30 years ago and doesn't contemplate the sophisticated tax structure. When you're doing this kind of planning, you need to ensure that the will contemplates things properly. So these are all areas that are really critical. Now, one of the things that's really super important is life insurance. And if you cannot really effectively do proper estate planning without using life insurance. Why? Because you're using pennies to buy dollars. Essentially, when you're buying insurance, particularly when you're younger, but if you're older, it works very well as well. We had people say to us, oh, well, I won't know anyway when I'm dead. Well, at the end of the day, what you do today will impact the well-being of the family. By the same token, an individual might turn to me and say, well, I want my son to inherit the company when I die. Well, I thought you said you didn't care because you wouldn't be alive. Maybe you do care. Maybe the problem is just too severe. Maybe the solutions are too elusive. So I'd like to talk a little bit about the way that we can plan for eventualities, right? Whether or not you remain in Canada, you eventually will die. That's reality. 74 bracket 5 of the Income Tax Act states that on death, taxes are paid, capital gains taxes are paid on the death of an individual. Taxes can be deferred but not forgiven when they're left to a spouse. But upon the death of the second spouse in Canada, capital gains taxes need to be paid. So when we see people that have life insurance policies that they've maintained for decades and then cancel them, well, that's great for the insurance company because it's pure intake of premiums and nothing being paid out, but it's very bad for the family. And in reality, that's what makes insurance a bargain, is because of the fact that many people do just that. It causes premiums to be much less. So at the end of the day, what we'd like to do here is leave you with some concepts that can provide for a number of different issues. And what I'll do is I'll share a slide with you that can describe how an estate freeze can be achieved, how intergenerational tax planning can be achieved along with asset protection, and also to fund against the inevitability of taxes on death, and also to provide for some benefits during the time that we're still alive. So this is, oops. Yeah. Slideshow. Okay, so what we'll talk about here is the fact that there's often situations, and maybe outside of Canada, where we want to give real careful consideration to where the assets are. So we talked previously about, a situation where there's active assets in jurisdictions that either have a tax treaty, and in some cases they don't have a tax treaty. Sometimes it's an information exchange agreement between various different countries. But one of the things that we're really careful about is to say, let's separate the corporations by jurisdiction. So if you have companies in the US that are commingled with companies in Canada, it's very problematic because it causes the loss of capital gains exemptions. When you use a trust, you might have multiple capital gains exemptions. So in other words, what we're really doing here is we're taking assets and putting them under a corporation, having all the future growth go up into into a trust. In this particular diagram, what we're really attempting to do is three things. One, where it's not demonstrated in the diagram, but we would be purifying a Canadian company by ensuring that the foreign companies are separated. Two, we'd be creating asset protection, not only at the opco level, an active business, but also at the holdco level to some extent, for a number of different reasons. Because if there's a claim against say there's a negative tax assessment in the US or Canada, and the same holding company holds the shares, well, under Section 160 of the Income Tax Act, as an example, CRA could reach in and take any shares or any assets there if there were dividends that were paid where there was a negative assessment, and that may include assets such as a US company. The US tax authorities may decide to do something very similar. So what we're really doing here is we're looking at combining an insurance plan that can fund capital gains taxes at death, can provide for key man insurance. So in other words, if the executives of the company are necessary for the company's longevity, having funds there to pay for that, all tax-free, even if it's paid to a corporation. In this particular case, we have a special purpose vehicle, which is an insureco, basically is established for the insurance. And then lastly, we were able to create state equalization. So beneficiaries of a trust don't have to be identified. Well, notwithstanding new regulation in OECD countries, where there's going to be mandatory reporting of all trusts, all individuals. And of course, in Canada, they're using the tax system in order to enforce this, which is another story for another day. But at the end of the day here, there's much that can be done for beneficiaries of trusts. And basically what we're looking to do is to move funds depending on where the country is, whether it's only in Canada, the US, elsewhere, but we're looking to send funds over to Insureco. And maybe Jordan, you'll explain how that works and what the benefit would be while the person's still alive.
Yeah, sure, absolutely. Well, I mean, maybe just to start with, just to review what you said, I mean, the reason why life insurance integrates so well with an estate-free strategy like this is it makes up for some of the inherent limitations that an estate freeze might have, depending on the circumstance. So one of which is, well, the idea behind an estate freeze like this is oftentimes to be able to limit the tax liability of a primary shareholder. But so the estate freeze allows him to pass on the future growth of his companies to the next generation, essentially kicking the can down the road. What it doesn't really help with is limiting the tax liability on the current value of the shares of the company at the time that the estate freeze is done. So for example, if the preferred share value of his Canadian company has a value of, let's say, $5 million when the estate freeze is done, the freeze will help him to be able to limit the future tax liabilities, but it's not reducing that current tax liability that he has now. And so that creates a need for life insurance to be able to produce funds to be able to pay for that capital gains tax liability when he dies, along with expenses such as key person expenses. So that would be used to be able to replace the primary shareholder, to be able to hire someone to fill his role potentially. And also just some of the more hallmark insurance needs, such as being able to pay for income replacement for the dependents of the company shareholder in this case. But within the structure that we have here, there's another way that life insurance is being used to be able to personally benefit the shareholder while they're alive. And so in this case, we are depicting the use of financing that would generally be equivalent to the premium that's being paid by the company that's holding the life insurance policy in this case. So what we're picturing here is we're picturing the shareholder's insurance holding company paying a premium of $250,000 towards a whole life insurance product, or potentially a universal life insurance product. And from there, the life insurance policy is being used as collateral to secure a loan that's equivalent to that premium. So there would be a $250,000 premium that would be paid towards the life insurance policy. And from there, a bank would be using the policy as collateral to enable them to borrow $250,000 personally. That would be using a corporate asset to be able to receive personal borrowing in that case. And so there's a lot of flexibility when it comes to insurance financing and leveraging. Funds can be either borrowed directly by the shareholder to be able to supplement the personal cash flow, or funds can be borrowed directly by the company that's holding the life insurance policy to be able to create a loop to fund the policy. But it really just depends on what the shareholders' needs are. And so oftentimes shareholders are looking to be able to supplement the personal cash flow. And in that case, there wouldn't be any tax that would be incurred upon the receival of these borrowed funds. But at the same time, they're being able to finance some of the insurance needs that we've mentioned previously. So they're not only benefiting the next generation from the investment of the life insurance policy, but they're also able to personally be able to access funds from their company tax-free through the usage of bank loans associated with a life insurance policy.
I think one of the things that get often overlooked is the fact that life insurance has a sacred status in the Income Tax Act. There's no tax on death benefits. Cash value can grow subject to certain limits without any tax whatsoever. And ultimately, even if a corporation is used to purchase an insurance policy, which by the way makes sense because say as an example, there's a small business deduction and you're being taxed at only 12.5% in Canada. Well, the reality is that you're paying for insurance premiums with 87.5 cent dollars. Well, even in that situation, a death benefit paid into a corporation creates a capital dividend account, which allows for the opportunity for those funds to be paid out tax-free. Many times when we are integrating corporate reorganization strategies with life insurance concepts, we will use life insurance shares. And life insurance shares will essentially mirror a capital dividend account value or sometimes death benefit. So those are some of the things that can be done. And I noticed here that we're drawing pretty much to the end of our program. I would just maybe ask for some concluding comments from our panel, and then we'll open up the floor for questions, maybe starting off with you, David. Some concluding comments?
Well, one of the things also, Todd, is death, of course, is an event certain with an uncertain event date. We know that's going to happen at some point. We just don't know when. But another, and is somebody going to sue you? That's a unknown. But one of the things that people often overlook is divorce. That's not a black swan event. That happens 50% of the time. And this type of structure, the asset protection you may have, and you and your wife may be fine, but if you've got children, statistically, half of them are going to get divorced. And this structure could serve for succession planning, can deal with asset protection, can deal with divorce protection, because just like you don't on death, you don't want to have an heir be the unwanted partner. You may not want a disgruntled ex-spouse being a partner. So it's all part of the planning to take into account. And I'll leave kind of one short story. When France brought in its ultra-millionaire tax, all of a sudden I started getting French clients. And I had a French gentleman that called up and said, "Oh, my wife says we should move to the United Kingdom, divorce capital of the world, because it has this wonderful non-dom tax system." And I said, "Well, sir, we have, lawyer-client privilege here. Can I ask you a question?" And yes, I said, "Do you have a girlfriend?" And he said, "Well, I am French." "Okay. What does your wife think about this?" "Well, she's not French, but she knows I am French." And so I explained, well, tax is a percentage of income. Divorce is a percentage of capital. And I told him about the UK divorce rules. And, oh, yeah, never hired me. And of course, 2 years later, Daily Mail had the great story about how the wife had taken him for half of his stuff. So it's one of the things, better than a prenuptial, which is a difficult conversation that a lot of people don't have, is to use this type of tax planning. Maybe not for yourself, you and your spouse may be fine, but what about your children and your grandchildren? When you're talking about generational wealth, it's another, white swan to protect against.
Excellent. Andy, so closing comment, please.
I don't really have anything to add, but we've been talking about planning in advance, but what happened if it's too late? So if you do have to pay taxes, let's say you departed from Canada and you just realize after this webinar that you have to pay departure taxes. I'll encourage you to hire a tax expert to prepare a voluntary disclosure program application for you, which could eliminate some of the interest and penalties.
Very good. Jordan.
Yeah, so absolutely. I mean, as Todd and David had mentioned extensively, I mean, the most costly path of action is really neglecting to be able to institute planning measures. And I think a solid piece of advice would be able to build a structure that allows for additional flexibility to be able to adapt as life circumstances change, whether that is departing Canada, whether that is taking into consideration just sort of marital status of children who are inheriting the shares of a company business owner, for example, or whether or not that's a matter of having contingency plans in case of, let's say, shareholder disputes of a company.
Very good. So one comment I'll make, by the way, and just hitchhiking on, what David said, about marital breakdowns and so on. One of the things that I've often seen is situations where individuals were advised by lawyers and accountants, or perhaps by their own thinking or other well-meaning individuals, that since they're already married, well, spouse is going to get 50% anyway, so make the spouse a shareholder as well, 50% each. Well, does that necessarily make sense? Because under the Family Law Act, depending on your jurisdiction, there are certain protections that are available and for a spouse, but there's other protections that are available for shareholders. There's shareholder oppression remedies, and there's all kinds of issues there where shareholders can exercise very powerful measures in addition to what might happen in a marital breakdown if it was just a spouse. So I would leave that one thought for you, that it may not necessarily be the most prudent thing. And again, I'm going to suggest that trusts are something that can solve a lot of these issues to begin with. So on behalf of our panel, we'd like to thank you, international tax and immigration lawyer David Lesperance, associate in quantum business law, Andy Yip, partner here in quantum business law, Todd Louis, I think you know me, Jordan Louis, who's also an associate and a partner with our family office. Also, we're really pleased that everybody could join us.